my lady. I appear for the appellant, Mr. Gupta, Mr. Robinson, KC, and Mr. Littlewood appear for the respondent, Sucden. This is, as your lordships know, Mr. Gupta's appeal against the order of Mr. Justice Knowles of the 30th of July 2025, dismissing his jurisdiction charge. I propose to deal first with gateways 9A and C, the place of damage gateways, then with gateway 9B, based on what's been termed the London meeting, and finally with gateway 3, the necessary or proper party gateway.
Yeah, can we refer to them by their names rather than numbers?
Yes, my lord.
Thank you.
My lord, I understand that we have 4.5 hours, so I'll endeavour to finish within 2 hours to save some time for reply. I'm conscious that your lordships and your ladyship will have read the skeleton argument, so I'm not proposing to go over the facts, and I'll endeavour to be efficient, but if I'm failing in that regard, please do move me on. My lord, turning to the tort gateways, both of these gateways turn on the same question, whether Sucden has suffered damage in England. There are, of course, some differences of principle between the place of damage gateway and the governing law gateway, but neither party contends in this case that it makes any difference. I accept, of course, that under the place of damage gateway, only some significant damage is required. That's well known from Metal and Rostov. Don't dispute that, but Mr. Gupta's case is that none of the actionable damage occurred in England. I also accept, of course, that the governing law gateway could, in principle, be enlivened.
So your case is that none of the damage occurred in England?
Yes, my lord.
Not that there is no damage.
I don't say on this appeal that there's no serious issue to be tried as to whether there's damage or not. I accept also that the governing law gateway could, in principle, of course, be enlivened if English law applied on some other basis. But the only basis on which my learned friends advanced that gateway in this court, and the only basis advanced below, was Article 4.1 of the Rome II regulation, rather than any other way of applying English law. So what I propose to do is to start by trying to encapsulate what I say, what the right analysis is, and then to go to the authorities to make that good. Sucden says that it was fraudulently induced to do two things. First, to delay enforcement, to delay bringing its claim against TMT, first defendant. And second, to accept the bills of lading, or the cargoes it represented, as security. And we see that clearly in the particulars of claim at Core Bundle 15, page 105, at paragraph 29, where those are the two things which it says it was induced to do. Now, on Sucden's case, both of those things turn out to be harmful. But what I say is that neither form of damage occurs, if it does, in England. First of all, delaying enforcement turns out to be harmful because, but only because, and only to the extent that TMT's position deteriorates in the meantime. That is why it claims in tort only if and to the extent that Sucden can no longer recover against TMT. That's how it puts its case at paragraphs 48.1 and 48.2 at Core Bundle 15, page 113. And that is why there was a good deal of evidence before the judge comparing TMT's position at point A compared to point B, in particular showing that it had assets, it was said, in May 2022. Damage, I say, occurred as and when TMT's position deteriorated. The effect of that...
Sorry, say that more slowly. Damages occurred what?
As and when TMT's position deteriorated. Because the effect of that is to erode the value of Sucden's claim against TMT. That damage crystallises, if it matters, when TMT goes into liquidation in Switzerland. But both of those things occur in Switzerland, I'll say. And my learned friend says...
Sorry, both of what things occurred... You've got to take this... If you're going to make submissions, we need to write down. You can't just say them and pass on to another submission until we've
I'm sorry.
got it.
I'll try and take it.
Yeah, try and take it at a sensible pace if you can, please. So
My lord, I'll come on to the authorities, but the diminution of TMT's position
yes,
occurs in Switzerland, I say.
the
because that's where it
diminution
starts.
of its position occurred in Switzerland.
And, if relevant, the crystallisation of that damage also occurs in Switzerland because that's where it goes into liquidation. And my learned friend says that damage is suffered where TMT should have paid the money comprising its debt to Sucden. I'll say that's the wrong analysis, and I'll address his authorities. But if there is an analysis based on non-receipt of value, then I say it is where TMT purportedly provided the security, which was the other side of the bargain.
How did purportedly providing security that wasn't in fact valuable security cause loss?
Well,
What causes loss is presumably not enforcing the pre-existing unsecured debt on the basis you think you've now got security for it.
but that's my primary position is that it is where TMT deteriorates because the focus ought to be on Sucden not being able to enforce as a result of that deterioration. An alternative position, I say, is if the focus is on the other side of the bargain, if Sucden's complaint is to be characterised as having been missold security that was not valuable, then it suffers loss when it receives the security which it thought was valuable but is not.
I mean, that would be an expectation measure of loss that might sound in contract, but
Yes.
I don't understand how it works in a tort claim.
Well, and that's the reason why I say that it's not the right analysis, and I only put it as an alternative. Now, on the other side, the second form of damage is taking the security itself, and that turns out to be harmful, as it happens, because Sucden sells that security for less than it costs to do so. So it's missold this security. It ends up selling it for about $50,000, but it incurs about $100,000 in demurrage and expenses in order to achieve that sale. So I accept that that's a separate form of damage, but I'll say that that damage doesn't occur in England either. That damage occurs in China. Can I then turn to the cases? And I say that the cases draw a distinction between a prefatory act, which creates a risk, or the circumstances in which damage can occur, and the subsequent damage which does occur in those circumstances. The first case is Eurasia Sports. That's at Authorities Bundle 25, page 707.
Well, why are we looking at these cases? What's in dispute about these cases?
Well, my lord, I say that that these cases show the distinction between the prefatory act, which just creates the risk, and illustrates that the right analysis is that merely forbearing to enforce is just that prefatory act. My learned friend says, no, waiting to enforce is the damage itself, and therefore it's suffered in England. So I'd like to draw out that distinction. So my lord, in Eurasia Sports, the claimant was a betting agency. It was incorporated in the Channel Islands, operating through staff.
Which page in the bundle is it?
It's page 707, it starts. If we pick it up at page 710.
Pages are all out of kilter with the electronic bundle.
I'm sorry about that, my lord.
It's not, and it's also not at 707 in the paper either. So, what page is it?
I think it is 707 in the paper. At least my paper copy.
For those in like me in the analog world, it's Vol 2, Combined Authorities Bundle, tab 27, page 787.
27, isn't it? Let's see.
I'm so sorry, my lord.
Sorry, tab, that was my mistake, tab 25.
Tab 25.
Tab 25. It's internal page 6092 of the case.
Thank you.
I haven't got this bundle. I've got another bundle. You can, my JA will try and send it to me.
So sorry, my lord. But in the meantime, perhaps I'll
Well,
describe
in the meantime,
what it is.
just wait, please.
I'm sorry.
I don't know if it helps, but my learned junior does have a hard copy of the authorities.
I don't use hard copies. I can't see them.
Understood.
Thank you. So, Patrick, can you try and send it to me? You've done that, have you? Thank you. I mean, I downloaded it this morning, and it's. I mean, the one I've got has got 1,054 pages. How many pages are there in the paper?
But the joint bundle has about 1,300 pages.
1,300.
Yes.
1381.
Sorry about this, but I have got it now.
My apologies for the confusion.
Right, 707.
Yes, my lord. And if we pick it up at page 710.
Pages are still not. Right, okay, 710, thank you.
Oh, yes. So this case, the claimant was a betting agency incorporated in the Channel Islands, but it was operating through staff, including 2 who were in London. The defendants were gamblers to whom the claimant agreed to extend credit, that is, provide an account that they could use to gamble and accrue losses. The defendants obtained that credit by agreeing to provide security. And we see that first in paragraph 5 by letter G on page 710. At the start of that paragraph, the first and second defendants were to provide security of $1 million. And we see towards the end of that paragraph, only half of that arrived. Second, at the bottom of the page, security was to be provided in the form of a $10 million check, which was delivered to the claimant's bank in Malta. Over the page, we see that the apparently valuable security was in fact worthless because the check was provided, but it bounced.
When you say over the page,
At
we have
paragraph
numbers.
At paragraph 8, my lord, the cheque for $10 million payable to the claimant was presented, but not paid.
Mm-hmm.
The formulation of the claim that was brought is at paragraph 9. The claimant had been fraudulently induced, it said, to provide gambling services by false representation that money was had been or was about to be transferred, or alternatively, that they'd been secured by the third defendant's cheque for $10 million. The judge below had found that the claimant's damage occurred in England. His Lordship's reasoning is at page 715. In a quote at paragraph 27, and in particular, about 7 lines up from the bottom, His Lordship held that the question was where the damage to the claimant was caused. That, it seems to me, occurred in the place where the claimant allowed the bets to be placed by the conspirators in the belief that the risk was less than it truly was, because the various offers of security were worth less than they were said to be worth. So in effect, His Lordship considered that the damage occurred when and where the claimant stood by and allowed the risk to materialise in the belief that the risk was lower than it was. Over the page at 716, just by letter F, we see that Lord Justice Floyd disagreed with that reasoning. At paragraph 30, His Lordship held, towards the end of that paragraph, that the act of extending credit didn't itself constitute damage, but it was akin to the offer of an overdraft facility. And we see His Lordship held 3 lines up from the bottom. Damage is sustained where the defendant places a bet and loses. The provision of credit merely exposes the claimant to the risk of damage, but does not itself amount to damage. So, I say at stage 1, the claimant agrees to extend credit. That doesn't amount to damage in itself, but it provides the conditions in which the damage can occur. If the gamblers don't place any bets, then there wouldn't be any loss. But at stage 2, the damage actually occurs. In Eurasia, it's the placement of bets, presumably in Peru, where those defendants were based. But it's only at that stage that the defendants actually become indebted to the claimant, and the claimant suffers loss. Now, Lord Justice Floyd also had an alternative characterisation of where damage was located, which we see at the bottom of page 716, paragraph 32. His Lordship says that if damage is characterised as the impact of the failure of the defendants to meet their monetary obligations by providing security, then it seems to me that it's clear that damage is felt in the place where the money was received, which was Malta. And that's why I put forward my alternative case, that if one looks at the other side of the bargain, if one characterises the complaint as being missold security that turns out to be worthless, then damage is suffered in the place that that security was delivered. But in our case, as in this case, there's no suggestion that that occurs in England. And my learned friend's characterisation of this case is in his skeleton argument at paragraph 18. That's in Core Bundle, tab 7, page 65. And he says the comparison with Eurasia is misconceived. The allegation was that the defendants had procured the claimant to provide gambling services without security by falsely representing that the money was about to be transferred to the claimant. In other words, the conspiracy led to the creation of unsecured debts. By contrast, the present case involves the inducement of the delay of enforcing a debt that already existed. So my learned friends draw a distinction between the creation of the debt, which they say is erasure, and the delay in enforcing a debt that already existed, which they say is this case. But my lords, I say that breaks down at 2 points. First, it's based on a misreading of erasure, because the prefatory step in erasure was not the creation of unsecured debts. Stage 1 was offering the credit, offering the account, in effect, offering an overdraft. On the contrary, Lord Justice Floyd found that damage occurred when the defendants placed the bets and thereby became indebted. So I say the cases are aligned. The provision of gambling credit in erasure and the delay in enforcing in our case, neither of them on its own changes the claimant's position. Both simply create the conditions in which that damage can potentially occur. That's the first way in which it breaks down. The second, I say, is it elides what I've called stages 1 and 2, risk and damage. And we see that elision, in my submission, most clearly towards the end of paragraph 18, 3 lines up from the bottom, where my learned friends say this. They say, Sucden delayed the enforcement of the debt, delaying the enforcement of the debt, and thereby being deprived of the ability to enforce it against TMT. But my lords, my lady, those are 2 different things. Sucden was not deprived of the ability to enforce the debt just by delaying. It was only deprived of the ability to enforce it against TMT if, and insofar as, TMT's position deteriorated in the time that it was forbearing. So that's the first case. I say the principle that one sees from it is consistent with more general proposition in relation to contingent damage. The damage doesn't occur where the risk of loss first arises. It only occurs when that risk actually materializes, when the damage actually manifests itself. And that terminology of manifesting damage emerges from the Article 4.1 and Article 5.2 Lugano cases. In particular, Kwok and UBS, which is the second case I'd like to turn up, with which, of course, my Lord the Master of Rolls will be very familiar. That case is in Authorities Bundle 34, page 1293. This was a case under the damage limb of Article 5.3 of the Lugano Convention. The facts are usefully summarized on page 1297. Paragraph 5, quoting from the learned judge below. In short, the claimant made a loss-making investment based on negligent advice. The investment structure was complex, but it was referable to certain shares, referred to as the H shares. And the key question was whether loss was suffered when and where the shares were first purchased, or when and where they fell in value and were ultimately sold by UBS. The learned judge and the Court of Appeal both held it was the latter when the damage actually materializes. We see the judge's finding over the page at paragraph 7. in the middle of that paragraph, the ladyship held paragraph 111 that the leading CJU cases demonstrated that it was the manifestation of the damage that was relevant, not the transaction that ultimately led to such loss. At paragraph 8, UBS contended that that was wrong, and we see there the general rule for which UBS was contending. It asserted that damage occurred where the claimant entered into a transaction, or failing that, where it paid for it. The Court of Appeal upheld the judge, and my Lord the Master of the Rolls' conclusion is stated succinctly at paragraph 13 on page 1299. And put simply, the harmful event for which compensation is claimed did not incur until UBS London sold the 8 shares. That was decided upon in London. Until that time, the wrongs alleged had not given a rise to the primary damage claim. After a review of the cases, that reasoning is then elaborated from page 1305 onwards. In particular, paragraphs 45 to 48. And as I understand it, here we see 3 things. First, that there's no universal rule in financial loss cases, such as UBS sought to establish. See that in paragraph 45, 5 lines up from the bottom. Second, what is clear is that it's essential that damage must manifest itself in the jurisdiction. That's stated at paragraph 45 and again at the bottom of paragraph 46. It's clear that the loss must manifest itself in the jurisdiction in question. And third, my Lord the Master of the Rolls departs from the learned judge below in one sense, and that is that it's not always necessary to look where the loss actually crystallizes and is made certain. One sees that at paragraph 48. But it made no difference in that case, and I say that makes no difference in this case either. If it matters, then the loss in this case crystallizes, as I said, when TMT goes into liquidation, but the deterioration of TMT's position over time occurs and damage manifests in Switzerland anyway. And the conclusion over the page at paragraph 52 is that the judge was right to answer the questions in favour of England and Wales. First, the substantive damage claimed did indeed only manifest itself when the 8 shares were sold in London. And again, I say that aligns with this case, where the Prefatory Act of waiting to enforce against TMT doesn't itself create damage. And if TMT's position had improved, much like if the 8 shares had not dropped, then
it's a different factual situation, because in that case, the 8 shares had a real value and were dependent on the market. But in this case, the security had no value from the moment he deceived the claimant.
My Lord, that is right about the security. But in my submission, the relevant comparator is TMT, the value of TMT at the time. Because just as in Quok, the question was whether the value of the 8 shares dropped and loss was suffered. In this case, my learned friend's complaint is that it can no longer enforce against TMT. And so I say that merely waiting to enforce that debt didn't itself produce any harm. The harm is only suffered if and when TMT's position actually deteriorates and Sucden actually becomes less able to enforce its claim. My Lord, the third case is another decision of Mrs. Justice Cockrell, as she then was, in Jaffe and Grable. That is at Authorities Bundle 35, page 1309. This was an Article 4.1 case, and the same contingency issue, which Mrs. Justice Cockrell addressed in her first instance in Quark, is addressed again in this case. In short, Wirecard was acting as an acquiring bank for payments to Monarch Airlines. We see the nature of the services that it was providing summarised at page 1312, at paragraph 11. What Wirecard did was effectively act as guarantors for Monarch Airlines passengers. So if Monarch failed to perform its services and a chargeback fell due, Wirecard would pay the customer and then recover from Monarch. Wirecard alleged that it was fraudulently induced to enter into an agreement to provide those services, and the agreement was referred to as side letter 7. The representations are at page 1339, paragraphs 158 and 159, and the reference to side letter 7 is later in the discussion of the facts at 1342, paragraph 182. And what then happens is the airline goes into administration, so when the customers claim from Wirecard, Wirecard can't recover from the airline. But the important point, which I'll go to in a moment for present purposes, is that entering into side letter 7 to provide those services didn't itself amount to damage. That was a contingency. That just created the occasion on which damage could occur. The relevant discussion starts at page 1363 under the heading Choice of Law, paragraph 289. But the relevant part, we can skip forward to page 1365, internal page 57. At paragraph 295, Her Ladyship refers to my Lord, the Master of the Rolls decision in Quark, and identifies, of course, that it's dangerous to define the real rule too tightly, and it is likely to be fact sensitive. Paragraph 296, Her Ladyship says that having said that, there is some guidance to be gained from the authorities. And at Roman numeral 1, we have a series of cases where damage occurred at the time of the transaction. At Roman numeral 2, Her Ladyship explains that those cases don't lay down a general rule, not least because they were based on their own facts and or the loss was non-contingent. Over the page at 1366, at paragraphs 297 and 298, the Ladyship sets out candidates for locating the damage in England or Germany. For our purposes, the one I'm interested in is 298 Roman numeral 2 sub A. One of the points said to locate damage in England was that side letter 7 indirectly exposed Wirecard to the contingent risk of liability if customers entered into the credit card transactions with Monarch for flights and that it was unable to provide customers with them. And we see how that was treated over the page, paragraph 299. In the middle of that paragraph, side letter 7 did not immediately cause Wirecard damage and would not inevitably do so. It took a further contingency, the administration of Monarch, and the application of the relevant rules to manifest the chargebacks. So again, the side letter, I say, is the prefatory act. It creates the risk, exposes Wirecard to the risk that these chargebacks will be claimed and will be unable to recover them. But it's just like the extension of the overdraft or credit to customers in Eurasia, or the forbearance from enforcement in our case. All of these acts just create the circumstances in which damage can occur rather than constituting loss themselves.
And Mr. Trotter, you and I, of course, have had a run through of these authorities before.
Yes, my lord.
on which I've delivered a judgment that doesn't appear to have made its way into the bundle of authorities. And for the benefit of those not familiar with it,
Yes.
if we identify tort law as a wrongful invasion with a legally protected right or interest, what is the right or interest on behalf of Sucden that was the subject of the wrongful interference in this case?
Yes, well, my Lord's decision, of course, in Commercial Bank of Dubai identified specifically that in a case involving malicious prosecution, where the interest being protected is not being exposed to unwelcome litigation before a certain set of courts, then that is itself harmful, an interest that could be protected, and damage ought to be located in that place. By contrast, my Lord in that case referred to more decentralised torts. The example my Lord gave was in MX1, I think, of publication of tweets around the place that didn't itself locate an interest that was being invaded, and one needed to look, therefore, at where the damage occurred on a different basis. And I say that in this case, it's more difficult to identify.
Isn't the legally protected interest or the right to be paid the debt? Isn't that what the wrongful interference is? It's the English law debt payable in London that's been interfered with.
My Lord, that would be right if the wrong that was being alleged was inducing a TMT not to pay, operating on a wrongdoing that was operating on TMT. But that's not my learned friend's case. My learned friend's case is that the wrongdoing operated on Sucden to stop it from taking steps in order to enforce its claim. And that's not an artificial distinction, because it sounds both in the way the claim is framed, but also potentially in the damages that are recoverable. Because my learned friend doesn't say that the value of its claim is the full amount that TMT would have paid, or at least it may not necessarily be so. Instead, there'll be an inquiry at trial about how much better off Sucden would have been had it taken enforcement action at an earlier stage.
Well, necessarily so, because that is the sort of inquiry that would almost never be appropriate at a jurisdictional challenge. It's a matter for trial.
Yes.
But at the moment, at least, I am struggling to identify what the legally protected interest that has been wrongfully interfered with or invaded here, if it's not the debt.
Well, my Lord, the way that my learned friend frames his claim, the protected interest is the ability to pursue the claim against TMT in order to recover that debt. Because that's the way the claim is framed. And that claim, that shows in action, I say, is located in Switzerland, where the debtor is.
Right.
Can I perhaps deal with my learned friend's cases, because that, I hope, will help elucidate my position, but we shall see. My learned friend, of course, leads with Dolphin Maritime and that line of cases, so perhaps I should go to those. Dolphin Maritime is at Authorities 15, page 387. The facts are summarised in the head note, particularly from G through to J. In essence, the claimant is an agent paid on commission. The claimant is instructed by the insurers to recover compensation from the ship owners in respect of cargoes lost at sea. The claimant does strike such a deal with the club who represents the ship owners' interests. The club was then to pay the claimant, Dolphin, who would take the commission and pay the rest of the settlement on. Now, the complaint in this case we see was at page, is it 394? By letter B, paragraph 13. And in essence, the complaint is that the insurers and the club agreed to cut the claimant out, so that the club just paid the insurers directly. And I'll go through the reasoning, but the core point that I make is that the obligation that's breached is one that operates on or affects the conduct of the paying party, not the enforcing party. And we see that that's central to the reasoning. First, we pick it up at page 398. Paragraph 31 at the top of that page makes the point, which of course your lordships and your ladyship are familiar with, which is that damage doesn't just occur where the economic loss is ultimately felt. The case law in this area of the law is hostile to analyses which result in that. And I say that one needs therefore to find the limiting principle. Then the core of the reasoning is over at page 405. Paragraph 56. Mr. Justice Christopher Clark explains that, second line down, the underwriters were bound to procure that the sums recovered directly from the club were paid in the first instance to Dolphin. So that was the obligation. As it happens, an obligation on the insurers to procure payment from the club to Dolphin. At the bottom of paragraph 57, we see that the last two lines, the complaint in tort, is that the club wrongfully brought about a breach of that obligation on the insurers. And so that is the reason why damage is suffered where the money would have been paid if the obligation had been complied with. Because the gravamen of the complaint is that the obligation that was breached would have involved procuring the payment of money to Dolphin in London. And to answer my Lord Justice Foxton's question, that's because the interest that was being protected was that payment to Dolphin in London.
Let's imagine that the tortious conduct complained of here, and at the moment at least we do recognise a tort of this nature in this jurisdiction, was the removal of assets from the debtor wrongfully to leave it incapable of fully discharging its debt, the Marrick's tort. And would you accept that would be ordinarily felt at the place where the debt was payable?
Well, I think I would be constrained to accept that, my lord, yes, because in that case, that would fall within the Dolphin maritime paradigm.
So if my complaint is that assets were deliberately moved to reduce the creditor's prospects of recovery, you say that loss is felt where the debt is payable. But if my complaint is that the debtor was deceived into not exercising its right of recovery, during which period of time available assets diminished, you say that loss is not sustained worthy.
My lord, yes, and I see that my lord thinks that distinction is artificial.
I am struggling with it.
I'll endeavour to persuade my lord that it's not, because there's a material difference in the way that the claim is framed and its effect. So in the former case, of course, the Marrick's tort is derived from the tort of inducing breach of contract. In both cases, those torts involve inducing the paying party not to make payment, either by stripping assets or by operating on its will in some other way. That's not the complaint that's made in this case. It's not said that Mr. Gupta went about stripping assets from TMT. What's said is that it was the other side of the equation, that Sucden was induced not to take action. There's no evidence or no suggestion, no pleading that there was any wrongdoing that operated on TMT.
But the issue here is not the wrongful act.
Yes.
We're on the damage limb. And so you have to say that as a matter of common sense analysis, there is a different location of damage depending on whether you strip the assets out or you deceive the creditor into delaying while the assets are either stripped out or leave by some process of execution on behalf of another creditor. That's what you have to say, isn't it?
Well, I do, my lord, and I don't resolve from that, because once the Supreme Court in Ablyazov has made clear that the way in which the cause of action is formulated, of course, one shouldn't be over technical about it, but it can inform and does inform the parameters within which one is looking for the relevant damage or the relevant act. And the way in which Sucden has chosen to frame its claim doesn't allege that Mr. Gupta was stripping assets from TMT. It doesn't allege that he was willfully allowing it to run itself into the ground. Its claim, it would say, would succeed even if TMT fell into financial trouble for totally bona fide reasons. And so for that reason, the interest which it complains of being invaded is its ability to take action against TMT before that happened. And that, I say, the proper characterization is that the value of its right against TMT has been diminished over time, and the locus of that Schloss in action is in Switzerland. My lord, I won't go through the other cases, AMT and Pan-Oceanic, but I say the same analysis emerges from those because they're both cases where the obligation that was being breached, the basis of the complaint was that there was a breach of an obligation or inducing a breach of obligation to confer a benefit in England. So in AMT Futures, it's a breach of an exclusive jurisdiction clause. And in Pan-Oceanic, it's another commission agent case where there was a breach of an obligation to nominate certain cargoes, which would have led to payment in England. I'm sure my learned friend will go through those, but I say the same paradigm applies. My lord, then the other head of damage is the cargo expenses. Yep. And this
Just
is...
in terms of those, on Mr. Justice Robin Knowles' analysis, were those in or out at the end of the jurisdictional challenge?
I'm sorry, my lord.
The claim for the expenses realising the loss made when it turned out that scrap metal was in the container rather than something more valuable, and there's a claim for that loss. Was that found by Mr. Justice Robin Knowles to also fall within the gateway, the wrongful?
My lord, I don't think that the judge relied on that head of damage to find that the gateway was made out.
Right.
And indeed, it's not, in my learned friend's skeleton argument, it's not invoked in relation to Gateway 9, the place of damage gateway.
I mean, there is that gateway. You'll know this is a little bit of a hobby horse of mine, that if you have a gateway claim and the facts of another claim substantially arise out of the same facts as the gateway claim against the same defendant, you get that in as well.
Yes.
Gateway, I think, introduced by suggestion of Mr. Justice Hamlin, as he then was, and somewhat expanded in the process I was involved in. But would you accept that if you're wrong about non-payment of the debt, that gateway is going to be met in relation to the expenses?
My lord, that hasn't been relied on by anyone. I think I would have to accept that in any event, because there's only some significant damage is required for Gateway A.
Yeah.
It probably doesn't in reality need to get there. Yes. But my lord, in relation to the cargo expenses, the argument here is that these cargo expenses were borne in England, so that damage was sustained here. I say the answer to that is that the damage was sustained in China, where the expenses were incurred. That's where the demurrage was incurred. That's where the expenses relating to warehousing and so on were incurred. And indeed, that's where the cargo was ultimately sold, so that the damage manifests itself because the expenses turn out to be more than the value of the cargo. That is, I take from AMT Futures, which is in Authorities Bundle 18, page 489. And my Lord Justice Foxton is obviously very familiar with this case as well, because it's another of the ones that was referred to in Commercial Bank of Dubai. But in particular, at paragraph 49...
Can we be provided with the Dubai case, please?
Yes, well, we'll arrange that. At paragraph 49, standing back, the claimant in this case, this is the case where the claimant incurred expenses in Germany when there was a breach of a jurisdiction clause, led it to become embroiled in litigation there. And the question was where that damage occurred. In paragraph 49, we see that the damage suffered in Germany.
Yes, there were no Australian lawyers working in Australia in this case.
Sadly not, my lord. But it would have been immaterial for reasons which your lordship has given. And so the litigation occurred in Germany, the costs were incurred there. And over the page at paragraph 50, Mr. Justice Popplewell explains that it doesn't matter where AMT ultimately bore the expenditure by funding it. That's not initial damage in itself. It's merely the remote financial consequence of the activity in Germany. And so I say in the same way, the fact that Sucden paid the costs, if it did, from England doesn't mean that this damage occurred in England. The expenses are all incurred in China. Now, of course, my Lord Justice Foxton found in Commercial Bank of Dubai that the interest being invaded is the exposure to litigation. And that's an additional reason why, or perhaps even the true reason, why the damage occurred in Germany rather than elsewhere, regardless of where the lawyers might have been. But the point I draw from this is that the source of funds certainly is irrelevant, because that is remoter, and as your lordship noted in that case, the law in this area is hostile to that.
Well, it would mean you could choose the place of your tort by choosing the bank account from which you would make the payment.
My lord, yes.
Yes. Commend it.
Yes. And the same conclusion, a similar conclusion, was reached by Mr. Justice Marcus Smith in MX1. But that's in my skeleton argument. I perhaps don't need to go to it now. So that is the place of damage and applicable law gateways. The next gateway is the Substantial and Efficacious Act gateway, which I've badly termed in my skeleton argument 9b. Now, on this, I say two things. First, it ought not to be permitted at this stage, having not been relied on below. And second, it's wrong. I propose to show your lordships how things were dealt with below, and then to deal with the reasons why it's wrong and why other evidence could have been adduced compendiously. Now, of course, gateway, the place of damage gateway was relied on below, but the way in which it was relied on was very much based on this non-payment analysis. We can see that from Charlton 1, which is in the supplemental bundle. Tab 14, page 116. This is the evidence in support of the service out application. And Mr. Charlton's here explaining the basis on which paragraph 3.19a of the practice direction is relied upon. And it's very...
Which paragraph?
Paragraph 15 at the top of the page, my lord. And we can see it's very much based on the fact that damage was constituted where the defendant was obliged to pay funds and didn't do so. 15.2, that should have been paid to Sucden in this jurisdiction. 15.3, Sucden forbore. Had Mr. Gupta not made those representations, it would have taken steps to enforce. 15.4, it would have been payable to Sucden within this jurisdiction where its bank account is located. And so what one doesn't see here, naturally enough, is any close analysis of the London meeting, because it's just not in focus. It's not relevant to the way in which place of damage gateway is being put. And so there's effectively a legal dispute about whether this is the right way of analysing this gateway. And for that reason, there's no evidence in relation to this gateway about the significance of the London meeting. The closest that one comes is in a totally different context of forum convenience. Now, Mr. Gupta did serve evidence dealing with the London meeting in that context. That's in Mills Web 2, Supplemental Bundle, tab 30, page 217. There's a heading, not the appropriate forum, and then over the page at paragraph 43, there's an analysis of the various different events to which the claim relates. It said none of the events, with the exception of a single meeting, are said to have taken place in England, and the London meeting is dealt with over the page at paragraph F.
Sorry, I haven't got paragraph F. It's on page 219, isn't it?
Yes, my lord, over the page at page 219, subparagraph F. And Mr. Mills Webb explains that paragraph 33 of the particulars of claim refers to the London meeting, and he says that the sole point pleaded in relation to the meeting is that it was agreed that TMT was willing to further formalise the security agreement in respect of the bill of lading. This meeting therefore does not evince any new representation having been made. So of course this is in the context of forum convenience. It's all about the relative significance of the various events that took place. But of course, once Sucden raises Gateway 9, the Substantial and Efficacious Act gateway, the position is radically different. Because suddenly, the London meeting is in sharp focus. It's the entire hook for jurisdiction under this gateway. And the question of whether there was an actionable act committed in London is not just background to the forum convenience analysis, it's dispositive of the entire jurisdiction challenge. So that's the background generally. Then two aspects to this gateway. First, was there an actionable act in the jurisdiction which gives this court a legitimate adjudicatory interest? Second, was it substantial and efficacious? On the first, was there an actionable act? It is true, so far as it goes, that the pleaded account of the London meeting is admitted by TMT, and that defence is signed under a statement of truth by Mr. Gupta. But it's important to see the limits of that common ground. The particulars of claim is in Core Bundle 15, page 105. There's paragraph 33 that refers to the London meeting, as we saw in Mr. Mills' Webb witness statement a moment ago.
I mean, just as a matter of interest, each of the bundles in this case has wrong numbering. It is not beyond the wit of solicitors in 2026 to get the numbering in the electronic bundles to comply with the bundles in the paper form, and it is completely unacceptable for large firms of solicitors to produce bundles which make it very, very difficult for those working electronically to follow. And so I'd just like that to be noted, please. It's okay, maybe, in small cases with litigants in person, but in commercial cases and big solicitors, it really is not any more acceptable. it is necessary for the electronic bundle to be checked before it is submitted to the court.
My lord, yes, I'm very sorry about that. I realise how terribly inconvenient it is when one can't.
Well, it is terribly inconvenient.
Yes.
I can't follow it because your numbers are 6 out in one bundle, 10 out in the other bundle, 14 out in the other one, and I'm continuously scrolling through to try and find out which bundle we're in and which numbers I'm following. I mean, look, I do a lot of cases, and nowadays almost everybody gets it right. So I know it can be done.
I'm very sorry, my lord.
Yeah.
Can I ask, in this bundle, the core bundle,
Yeah.
page 105 of in the footer, can I ask which page that is for my lord?
It's 108.
This bundle is 3
There's
pages out.
3 pages in this one. The other one's different.
I'll-
But they're all different.
I'll endeavour to try and take
Well,
it
I
if
mean,
can't.
you won't manage it because it's, for some reason, quite difficult to get into your head, the 3, whether it's 3 up or 3 down. And I don't even want you to try. I can do it. I'm just making my point, Mr. Trotter.
That's very, very much well heard, my lord. Yes.
I can deal with it. I've had to deal with it before. It used to be very common. It's no longer quite so common. Right, good, thanks. On we go.
So,
I've
my
had
lord,
my say.
It's under the heading, the second representation.
Yeah.
And one sees how...
Sorry, which paragraph is it?
If we start at paragraph 32, I
32.
just want to show the scheme of how this part of the pleading works.
Yep, okay, got it.
And so, paragraph 32, there's a meeting on the 27th of May 2022 Mr. Gupta to discuss TMT's continued failure to satisfy the margin call. There's then another meeting on the 22nd of June 2022, this time in London, with Mr. Mark Bailey. That's the London meeting on which my learned friend relies. And we see what's said to have happened at that meeting. During the meeting, the latter, that is Mr. Gupta, confirmed that TMT would agree to formalise further the agreement contained in or evidenced by the reliance letter by way of the pledge of bill of lading as security for the debt. That's the letter that's already been entered into in relation to the bill of lading, which has already been collected. Then at paragraph 34, we have, accordingly, in August 2022, there are negotiations of the memorandum of deposit, and in the subparagraphs thereunder, we have various things that were said in the course of those negotiations.
On behalf of Mr. Gupta, but not by Mr. Gupta.
Yes, yes, my lord, yes.
Yeah.
And so none of these things that are said to have occurred in London, but they are, one can see the nature of the statements being alleged are, in effect, that the goods constituted nickel rather than something else. So, for example, in 34.3, one of the individuals is said to have proposed that the goods be defined as set out in Schedule 1, which contained a reference to the bill of lading and a description of the cargoes as shipping containers said to contain nickel. Then at paragraph 35, we have the representations as they're formulated. And the representations are, in summary, that the goods in the shipping containers were in fact nickel. Now, it's not immediately obvious from the scheme of the pleading that any actionable representation is actually said to have occurred in London. What appears to be alleged is that there are background meetings in paragraphs 32 and 33, and then that having occurred, there's specific exchanges in August, which specifically refer to the goods and specifically refer to nickel, and that those amounted to representations that the goods were, in fact, nickel. Now, the description of the meeting is admitted in the defence, but what is common ground is what's set out in paragraph 33.
Just in terms of chronology, help me. So
Yes, my
a
lord.
draft bill of lading, is this right, is in play before the London meeting. It crosses the line between the defendant side and the Sucden side.
Yes, my lord.
And that is a bill of lading, is it, that on its face purports to be a bill of lading for a cargo of nickel?
Perhaps I ought to just take the chronology back a little bit.
Yeah.
That there's what's called the first representation.
Yeah.
That happens in March. That's at page 103 of the core bundle, or page 106 from my Lord the Master of the Rolls. That is, there's various discussions set out there, but in effect the representation alleged is the same, that the cargoes were in fact nickel. And then at page 105 or 108, that's said to have induced Sucden to accept the bill of lading as security and to forbear from taking action.
But just at 33, is the reference to a pledge of the bill of lading a reference to the bill of lading, the subject of the first representation purporting to be a bill of lading for nickel?
Yes, that's how I understand my lord, yes. So the chronology point which I'm seeking to draw out now is that in March 2022, what's called the reliance letter is executed, induced by the first representation, and then Sucden does in fact collect the original bill of lading on the 25th of March 2022. And then it's after that that there are further discussions about formalising that agreement in another form at the meeting in June, and then in the negotiation of the memorandum of deposit that comes in August.
Well, I mean, the bottom line is in 33, isn't it? That Gupta confirmed that TMT would agree to formalise the agreement contained in or evidence by the reliance letter by a pledge of the bill of lading referring to nickel as security for the debt.
Well,
so that's what he agreed to do
my
in
Lord,
London.
I'm sorry.
Yeah?
I'm sorry, I cut across.
No, it's all right. That's what he agreed to do in London, to formalise the further agreement contained in the reliance letter by a pledge of the bill of lading referring to a nickel cargo.
And if you look at 35, isn't it a little unreal to suggest that that is not also a complaint? These discussions about a bill of lading apparently for nickel in London were fraudulent because there was no nickel in the containers to which the bill of lading related.
Well, that is the way that it's clarified in the reply, my lord. I'm not trying to take a technical pleading point.
Okay.
What I say is, though, that...
What are you doing?
Well, what I say is that the description of the meeting, which is common ground, it's not at all obvious that Mr. Gupta was making a representation about what was in fact in the shipping containers. Mr. Gupta's case...
Well, the whole... I mean, like all frauds, Mr. Trotter, the people on this bench have seen quite a lot of frauds in their, I'm afraid, rather lengthy careers. And like all frauds, you don't highlight in the fraud the problem that you're concealing. But here, quite plainly, the whole discussion is about a cargo of nickel worth $6 million, when in fact it's a cargo of stainless steel worth umpence.
Well, my lord, that is right.
Yeah.
But
But your point, as I understand it, is this has all been agreed in March.
Yes, that's the point on causation, which I'll come to.
Oh,
Yes, my lady, that is absolutely right. At the moment, all I'm seeking to say is that the way Sucden has pleaded its case is not that Mr. Gupta believed.
But we're talking about what Mr. Gupta accepts.
Well, Mr. Gupta accepts that there was a discussion about formalising the agreement.
Yeah.
His case is that he relied as much as everyone else on the accuracy of the bill of lading. And so what one doesn't have is any evidence of anything being said at this meeting to suggest that Mr. Gupta is in any better position than anyone else to know what is in these shipping
That's
containers.
just a tribal issue as to whether Mr. Gupta knew it was, the whole premise of the transaction was that he was pledging a container of stainless steel. But that's not really the point. The point is, what has he accepted in his pleading, or at least I thought that's why we were looking at this, and you were saying, well, he hasn't accepted very much. No, he hasn't accepted he's a fraudster. I think we understand that. But he has accepted that the discussion in London was about a cargo of nickel. And if the claimant is right, that was a fraudulent misrepresentation. Am I right? That's the allegation.
Well, my lord, I think all I can say on this, to encapsulate it briefly,
Yes.
is that if the point had been in focus, there could have been more evidence about exactly what it was that was said at this meeting, and whether it was.
That's for trial. Okay. Anyway,
I'm
you say what? That we can't hear it? That we shouldn't hear it? What's the submission?
Well, I say that it shouldn't be raised for the first time on appeal, because the contents of what was said at the meeting was not in focus, and Mr. Gupta didn't put in evidence about what was said. If he had done so, then this court would have been concerned on the first two limbs in Brownlee to resolve that dispute on the basis of the evidence as far as it could. But because we don't have the evidence, we're in the plausible.
I mean, the evidence may or may not matter, but I still would like to see what Mr. Gupta accepts in the TMT pleading.
My lord, yes, I'm perfectly happy to turn that up. That is at page supplemental bundle 18, supplemental bundle tab 18, page 142. And it's paragraphs 54 to 56 that deal with the second representation.
Right.
And so what's common ground at paragraph 54 is the description of the meeting that's been set out in paragraph 33. But then what's not common ground is that there was any representation. Paragraph 55, no representation was made as to the actual contents of the 9 containers. And this turns on whether Mr. Gupta was saying anything at that meeting that suggested that he was in any better position to know.
Well, how can you admit paragraph 34? I'm just going back to it. Oh, sorry, 33. Where they confirmed the pledge of the bill of lading, which everybody had seen, referring to nickel, without saying, and then deny, as he does in the supplemental bundle, no representation was made as to the actual contents of the 9 containers. What's alleged is they were having a discussion about a bill of lading which refers to 9 containers of nickel, and it doesn't matter whether he actually said anything about the nickel. That's their discussion, and he admits that. I mean, it's without being silly about it, it's how many angels can stand on the point of a needle. I mean, we don't decide service out cases by that.
My lord, I'll move on to the point about substantial
evidence. Move on to a better point. That's it. Great.
Your lordships will have seen how Sucden's case fits together. It's set out in my skeleton argument, and I've been over the chronology just now with the first representation leading to collecting the bill of lading.
Yes.
And then the second and third representations, which led to the formalisation of the same agreement.
And you're going to move on to the causation point.
Yes, my lord.
Yes.
Yes. Now, the central point here is that in order to show that the second representation comes after the collection of the bill of lading was collected, was causative, I say that my learned friend would need to plead a different counterfactual than what we currently have in the particulars of claim. Because my learned friend's case is that it's the first representation that induces Sucden to take security over the bill of lading, and that it does in fact collect that bill of lading on the 25th of March 2022. And once Sucden has collected the bill of lading and taken that security, then naturally its route of enforcement, if it becomes impatient, will be against the security. Now suppose it turns out at trial that Mr. Gupta cannot be held liable for the first representation. The question would then become, what would Sucden have done but for the second and third representations after it had the bill of lading in its hand? And the answer, I say, is obvious. It would have enforced against that security when it arrived in Shanghai, which, as far as Sucden was concerned, fully covered its debts. But that would have changed nothing, because it's common ground that the shipping containers don't arrive in Shanghai until the 14th of December 2022. That's in my learned friend's particulars of claim at page 109 of the core bundle, or page 112, at paragraph 42, which gives that date for the arrival of the goods, the unloading of the goods at the port of Shanghai. Now, even if one supposes that but for the memorandum of deposit, but for the subsequent representations, Sucden would have seized them immediately, inspected them immediately when they arrived at the port, rather than waiting to serve notice of defaults and so on. That means Sucden would have taken action in December of 2022, rather than in January of 2023. But there's no evidence at all, and no reason to suppose, that 1 month would have made a difference to its position against TMT.
So this is the presupposition is the only action that would have been taken is attempt to enforce security, not to demand repayment of the debt, and then trigger the remedies that would arise more generally at law from the failure to respond to the demand.
Well, my lord, yes, and that's the most plausible thing that would have happened, because as far as Sucden was concerned, it has good and full security for its debts on its way to the port in Shanghai. Why would it go to the expense of instructing lawyers to commence a fraud claim, or even a debt claim, in England or anywhere, when it could collect and enforce against the very security that it had negotiated for that purpose?
So your point is, it doesn't really make any difference, the second representation, because they'd already got the security and they were going to enforce against that if they were going to do anything. And the fact that the second representation buttoned it all down and you've got a formal agreement doesn't make a blind bit of difference.
My lord, yes.
I mean, you get into the counter question now. What is the correct counterfactual? Assuming arguably a representation was falsely made at the June meeting in London that the bill of lading was indeed for a container of nickel. And you get to the question about whether that meeting could ever have happened without Mr. Gupta saying something about the bill of lading, because plainly if they had been told at that June meeting it wasn't a bill of lading for nickel, I think, but for scrap metal, this argument would completely fall away, wouldn't it?
Well, perhaps that's right. If the correct counterfactual was that in May 2022, Sucden had been told, by the way, this is a massive fraud, and there's nothing in that shipping container.
Well, just if you're in a world in which the topic has to come up, Mr. Gupta cannot say nothing about the contents of the bill of the containers. If you're in that world, then doesn't the counterfactual become one in which Sucden are put on guard, because he either has to lie that it is nickel or say nothing, which is a massive red, when asked, which is a red flag?
Well, my lord, this is another difficulty, really, that we don't have any information about what was actually going on at that meeting.
It was a jurisdiction challenge, wasn't it? But
yes. But the relevant counterfactual in my submission is that if either the meeting doesn't occur at all, or one has the meeting, which is to discuss, as we'll see in some of the evidence which I can go to discuss Sucden pressing for payment, part payments in relation to the debt, because there is a schedule for part payments that's entered into and various payments are made. But that Mr. Gupta doesn't agree to formalise the existing agreement in the memorandum of deposit, and he says what you've got is good enough. You've already got...
manages to avoid saying anything that implies the bill of lading has any real value, because if he were to do that, that would be on the current hypothesis, dishonest, and the counterfactual is one in which there is no dishonest statement made.
My lord, yes, because it's a
quite a difficult
counterfactual.
conversation.
I'm sorry.
It would have been quite a difficult conversation to have a meeting in London without saying anything that implied the bill of lading was what it purported to be.
Well, it's speculating because we don't have evidence of exactly what was said at the meeting. But my point is that even if he doesn't at that meeting make any such representation of that kind, then Sucden are already in a position where they say they're secured, and they would eventually enforce against that security when it does arrive.
Well, they might do all sorts of things. I mean, if he tells the truth, they might try and enforce their rights very quickly against every possible. I mean, if he tells the truth, he won't bother with the security when he gets to Shanghai, but he will bother with TMT.
Yes, no, I accept that. If Sucden at this stage becomes aware of the fraud, then the world is different. But I just say that's not the right counterfactual. Because
But I mean, there is a lot of law on this, and obviously, if you're put in the position you would have been in had the fraudulent statement not been made. But there are many commercial contexts in which that isn't a realistic outcome, short of putting the other side on inquiry that there is some major problem. And the question is whether, arguably, it would have been not practical for a meeting to discuss the progression of this arrangement to take place, in which Mr. Gupta managed somehow to stay on the right line, not saying anything to imply this bill of lading was worth the paper it appeared on, but with Sucden nonetheless remaining under the impression that it was so good that it wasn't worth taking any other steps to enforce. Now, I can see you might have an argument about that at trial. I don't think it would be an easy one, but that's not the issue here today.
Well, my lord, no, but again, I'm in difficulty because I just don't have any evidence other than those two sentences that have been admitted in the pleading.
What's your difficulty? I mean, what is the best evidence you could have adduced that would make a blind bit of difference to the argument you're having with my lord?
Well, Mr. Gupta may say in evidence we had this meeting in London to discuss the resolution of the debt. Sucden was pushing for us to make part payments. He did say in the summary judgment application, Sucden was pressuring us to close out positions. That was the whole basis of the summary judgment, the defence of the summary judgment application, ultimately unsuccessful, but not on the basis that what he was saying was untrue, just on the basis that it wasn't a breach of duty from Sucden. So he may say, well, Sucden was pressuring us to close out positions at the meeting. I was saying, well, that was horribly unfair and would drive TMT into financial difficulty. And then on the way out the door, Mr. Mark Bailey said, oh, would you mind if we just put that other agreement into a more formalised form? And I said, okay, I'll get someone to sort it out. Now, in that situation, it's a perfectly plausible counterfactual, where Mr. Gupta says, no, we're not putting any more paperwork together on that business is closed, and then leaves. That's not the sort of situation where Sucden then says, well, now we're going to go and launch a full set of proceedings and start a fraud claim and a debt claim, when we've got good security on the way to the port of Shanghai. So that's the causation point. My learned friend refers to Manic, the decision in the Court of Appeal. I say that's just a different case because that involves the piling up of various misrepresentations over time that ultimately leads the defendant to the claimant to sell their shares at an undervalue. And this is not one, I say, on the causation point where the straws pile up and ultimately break the camel's back. I say it's one where really the damage was done after the first representation, and that's why the counterfactual is pleaded in the way that it is. So those are the tort gateways. And I then deal with the necessary or proper party gateway. There are two questions under this gateway, and it's enough for Mr. Gupta to succeed on either of them. First, is TMT an available anchor defendant? And second, was there a real issue between Sucden and TMT, which it's reasonable for the court to try, and to which Mr. Gupta is a necessary or proper party? Can I start with service on TMT? The primary basis for Sucden's case has moved on somewhat. It says that it has relatively recently served TMT in Switzerland, having obtained various extensions of time in which to do so. Primarily, I say that it's not open to Sucden to rely on this service for the reasons set out at paragraphs 83 and 84 of my skeleton argument. Those are all mechanisms by which this court protects against a party failing at first instance and then trying to shift the ground in order to advance a different position on appeal. On the background, Sucden knew that there would be issues about service on TMT since 2023, because TMT initially indicated it would take issue with service, although it ultimately submitted to the jurisdiction. But it nevertheless decided to proceed on the basis of service in the jurisdiction under Rule 6.11 without taking any steps to serve out. And that's set out plainly in Sucden's submissions in resisting permission to appeal at Core Bundle, tab 5, page 46. Or page 49 for my Lord the Master of the Roll. This is the paragraph 19 statement in resisting permission to appeal. The anchor gateway is dealt with over the page on page 47 from paragraph 4 onwards. And then over at page 48, at paragraph 7, Sucden says this. They say, even if it's wrong, Sucden could have served D1 out of the jurisdiction without the court's permission under Rule 6.33. The ability to serve D1 out of the jurisdiction is good enough. And then this, that Sucden chose not to rely on this method and did not file the notice that would have been required is irrelevant. However, if it had chosen to rely on this method, it would have filed and served the required notice. The same point is made in my learned friend's skeleton argument on the appeal in the same terms. Don't need to turn it up, but it's at Core Bundle, tab 7, page 73, paragraph 43. We also know that Sucden had turned its mind to these jurisdiction clauses on which it now relies because it relied upon them in the service out application back in 2023. We see that from Mr. Charlton's statement, Supplemental Bundle, tab 14, page 113. And paragraph 13 on that page, just under the bold heading.
Sorry, could you give me the bundle reference again?
Oh, so sorry. It's Supplemental Bundle, tab 14, page 113.
Thank you very much.
Paragraph 13. Sucden submits that the intended claim can be properly served on TMT within the jurisdiction for the following reasons. And then there's a reference, paragraph 13.1, to the jurisdiction clause. Paragraph 13.2, the jurisdiction clause in the memorandum of deposit. And then at the end of that paragraph, a reference to the service agreement in the memorandum of deposit. Then at paragraph 13.4 at the end, Sucden believes that it can therefore serve within the jurisdiction on TMT. And similarly, over the page at paragraph 14, in dealing with the necessary or proper party gateway, paragraph 14.1, Sucden intends to serve the claim on TMT in the jurisdiction. So Sucden has specifically considered the jurisdiction clauses on which it now relies to serve out of the jurisdiction. It's also considered the service agreement on which it relied to serve in the jurisdiction, and it's decided just to rely on service in. And the fact that it chose just to rely on service in is clearly illustrated by the fact that it didn't file the Form N10 at the time. It had no intention of pursuing that avenue. Now, having taken that course, to seek to rely on it now, I say is abusive, for the same reasons as set out by this court in Kitani and Kundi. That case is in the authorities bundle at tab 14, hard copy, page 371. Now, the facts I don't rely on for any particular relevance, but in broad summary, it was a family dispute about the beneficial ownership of certain bonds held at a bank in India. The parties had jointly instructed an Indian lawyer to go and get the documents from the bank, but they were not forthcoming before trial. The claimant then elected to proceed to trial without the documents, and the documents emerged following trial. Now, there's a detailed history of all the efforts that were made to obtain these documents by the parties, starting at page 378, under the heading Admission or Not of New Evidence. But the conclusion in relation to those efforts is over the page at 380, paragraph 25, and the court explains that the history discloses that both parties deployed reasonable diligence in the task of obtaining the documents from IOB, that's the Indian bank. They began to seek documents in what could have been regarded as a good time before a hearing and took sensible steps, guided in part by the court, yet the documents had not come in hand. So, as far as the Ladd and Marshall criteria are concerned, perfectly passable. But the problem is that the claimant had elected to proceed without them. We see that over at page 382, paragraph 29. This is Mr. Justice Lindsay sitting in the Court of Appeal, and his lordship explains that the claimant had elected in the days immediately before the trial and as it began throughout the oral evidence, not only to proceed without the documents.
So this is a case in which after a trial on the evidence, some evidence that's been out there that the parties have made reasonable efforts to get, but they don't manage to land by the time of the trial, which is conducted on that basis, then goes on appeal, and there's an attempt to introduce post-trial fresh evidence on the appeal. It's quite far from the immediate context here, isn't it, of an interim determination on where a case should be tried, where service has taken a significant amount of time to effect that has eventually been completed.
Well, the distinction between the cases may be that in Kitani and Canby, we're talking about evidence that existed and had to be obtained from the bank. In this case, I imagine my learned friend would say it's a change of circumstances. So the evidence of re-service was not available before the judge because the service hadn't yet been effected. But I say that's a distinction without a difference, because it's evidence which was entirely within the claimant's power to create. No steps were ever taken to obtain the evidence on which it now relies, that is, of the service of TMT, and it chose not to do so, as it itself specifically says.
Understand.
Now, there's the same statement of principle as well from there's a Lord Justice Chadwick reaches the same conclusion over at page 385 to 386 of paragraph 40, but I won't turn it up. Now, if contrary to that, Sucden is entitled to rely on the service of TMT in Switzerland, then the question becomes, does that make TMT a party which has been or will be served within the meaning of Gateway 3 as at the time of the permission to serve out application? Because the issue has to be assessed at the date that permission was granted. And it's permissible, of course, to take subsequent events into account insofar as they shed light on the situation at the time, but not insofar as they are new developments. In other words, are the new circumstances revelatory of something that was present at the time the permission was granted, or are they constitutive of a different situation, which comes afterwards? And again, I say, at the time that permission was granted, TMT couldn't be described in that way. Sucden had put all of its eggs in the service in basket. It hadn't filed the N510 form, and on that state of affairs, TMT was not a party who would be served. The word will has to import, I say, not only an ability, but also an intention to serve. And insofar as service requires some essential precondition, such as filing the Form N10, there must at least be an intention to do that at the time. Not so, I say, in this case. Now, if I'm wrong about all of that, there is an outstanding application to set aside the extension of time that was granted in order to allow TMT to be reserved. That application, of course, is not before this court. It was only filed recently because it was only recently that the evidence was provided to my solicitors. In my submission, if your lordships find that the question of jurisdiction depends on the validity of service of TMT in Switzerland, the appropriate order would be to allow the appeal subject to that application. So, my lord, that's service out. The other form of service that my learned friend relies on is service in, under Rule 6.11. This point, I say, is really straightforward. The question is, was the claim solely in respect of the memorandum of deposit?
Right.
Because that's the agreement that contains the service clause. And in my submission, it can't be described in that way, for the reasons set out in my skeleton argument at pages core bundle tab 17, pages 153 to 156. The claim form does not even mention the memorandum of deposit. The particulars of claim bring claims that are all based on the trading facility, which is the agreement pursuant to which the debt was owed. You can see this in the particulars of claim at core bundle 15, page 100. This is the contractual debt claim brought against TMT. The paragraph 11 the trading facility is introduced and defined as the contract. And then over at page 101, at paragraph 14, we see the contract incorporates the terms of business. And over at page 102, at paragraph 20, we see the debt claim is in breach of the terms of the contract, that is the facility agreement, and or clause 8.1 of the terms of business, TMT failed to pay the debt. On the next page, paragraph 24, the interest is also claimed pursuant to the contract, that is the trading facility. And indeed, the memorandum of deposit is not signed until very much later, in August 2022, in order to provide security for that debt. The only mention of the memorandum of deposit is to explain why the notice of default was served. That's at paragraph 21 on the previous page, page 102.
It's in paragraph 7.1 as well, isn't it?
Oh, Lord, yes, that's the outline of the claim. And in the outline, my learned friend says that the debt and or damages plus other expenses are sought under both the terms of the contract and the contract of 2022. That's the memorandum of deposit. So I say that when one looks at how the claim is actually framed, the margin call debt is due under the trading facility only. And that's because it predates the memorandum of deposit. And the point where the memorandum of deposit comes in is into this claim is at paragraph 21, page 102, where it said that when TMT failed to discharge the debt, Sucden served a notice of default in accordance with the terms of business and the memorandum of deposit. And that's because by the time the notice of default is served in January 2023, the memorandum of deposit has been signed and the shipping containers are in Shanghai. Now that clause 7.1, all it does is create the event of default.
If there isn't an event of default, or at least until there is the debt due under the facility agreement payable?
My learned friend's case is that the debt was payable even before the memorandum of deposit existed.
But the memorandum of deposit grants some form of forbearance, doesn't it?
It does.
And so presumably the event of default is what removes that.
Well, the event of default allows Sucden to proceed with its claim and cease forbearing.
Yeah.
But it's still dependent at the source on the obligation that arises from the trading facility.
We probably want to look at the MOD clauses at some point.
My lord, yes, we can do that now. The memorandum of deposit is at core bundle tab 16, and the relevant clause is at page 125.
So this is the core bundle.
Yes, my lord. So core bundle page 125 or 128, my lord. And the clause that we saw mentioned a moment ago in the particulars of claims, clause 7.1, in the list of events of default.
Let's imagine you've got a debt accruing under the facility agreement that you enter into an agreement to provide contractual forbearance of under the MOD. But an event of default under the MOD then allows you to sue on the debt. Would that claim of debt constitute process in relation to any proceedings before the English court in connection with the transaction documents for the purposes of the appointment of service agent clause 26.3?
Well, my lord, the question for the purposes of the rule...
I'm just taking it in stages, Mr. Trotter.
My Lord, yes, I'm sorry, I perhaps haven't caught up with your...
So I suppose my first question is, does the claim to enforce this debt, which only becomes payable because the contractual forbearance is taken away by an event of default under the MOD, would that fall within clause 26.3.1, a claim to enforce the debt?
Within clause 26.3.1.
3.1 on page 132 of the core, because that's where the agent for service is appointed.
Transaction documents
Yes.
defined in 1.1.
So the question is that a claim in respect of, in connection with the transaction documents? Transaction documents.
It's defined in clause 1.1 on page 121.
I mean, it certainly includes the MOD, doesn't it, to the extent to which it's the event of default under the MOD that takes away the promised forbearance.
Yes. I think the words in connection with, of course, very broad.
Yeah.
And if one were talking here about a jurisdiction clause and whether it comes within the jurisdiction clause, I think I have to accept that that's right. But the question in relation to 6.11, I say is a slightly different one.
So, but stage one, are you with me at stage one, Mr. Trotter?
My Lord, yes.
And so I think what your argument then involves is, although that there is a contractual clause appointing an agent for service of this claim, the wording of 6.11 doesn't allow this claim to be served on that agent.
Well, my Lord, yes. Because that's
and
what...
At the moment, I find that challenging proposition. I would have thought that a claim that falls within the scope of the contractual appointment of the agent for service would fall within CPR 6.11, allowing you to effect service on that agent.
Well, my Lord, the rule has evolved over time and is becoming increasingly more restrictively framed to make clear that the only claim form that may be served out is one that relates to that contract.
Well, you can see that you certainly don't want you to be able to serve on the agent for service within the jurisdiction claims that the agent has not in fact been authorised to accept service of. That clearly would be something the rules would seek to prohibit. But I'm just trying to work out, you say that even if the agent has been authorised to accept service of a claim, CPR 6.11 wouldn't work for some claims. And that's what I will need help with.
Well, my Lord, the rule makes clear that it has to be a claim solely in respect of that contract. And
Should we have a look at it?
Yes, my Lord. The rule itself is at the
Page 14 and page 8, your page 8.
yes. Thank you, my Lord. So, where a contract contains a term, providing that the claim form may be served, that's the first condition. That, I say, is my Lord Justice Foxton's question.
I think you've agreed with me that is met, subject to further and better thoughts, which I will allow for, of course.
Thank you, my Lord. I'll always endeavour to do so. The condition B is that the claim has to be solely in respect of that contract.
But I mean, let's take it in stages. Again, let's assume that I've agreed to accept service of claims in tort, as I think you do under the MOD. Are you saying the effect of 6.111(1)(b is that you couldn't serve that claim because it's not in respect of the contract? Or do the words in respect of the contract simply mean a claim that falls within the scope of the term identified in 6.11(1)(a, which at the moment I regard as the more practical interpretation of the rule?
Well, I think all I can say to that is that this rule has been the subject of careful revision on a number of occasions. Where we've ended up is a rule that states that it should only be a claim solely in respect of the contract.
What practical goal would an interpretation that gave a narrower effect to the appointment of service agent clause than the parties had by contract advance, what would be the purpose that interpretation of the rules would be serving?
Well, one of the historical observations made in a textbook quoted in my Skellen argument is that this gateway is a bit of a relic because it's left over from a time when the gateways were very much narrower and serving out of the jurisdiction was very much more difficult. The modern scheme involves service out of the jurisdiction without permission in only very limited circumstances and relies on the court to accept that it has a legitimate adjudicatory function in relation to the claims under the various heads that are now elaborated in the practice direction. Now,
clauses of this kind are routinely included in their thousands in financial documents, loans, aircraft leases, ships mortgage entered into in this jurisdiction on a daily basis. And there is a long line of commercial court authority, at least on the interpretation of the clauses, which gives them a purposive and practical construction. At the moment, it seems to me your interpretation of 611(1)(b) would rather cut against that by saying that even if two parties dealing at arm's length have appointed an agent to serve a claim of type X and Y, it might be possible that claim Y couldn't be brought within 611, and then that would mean you could bring neither claim if you wanted to bring both of them, because 611(1)(b) obviously requires only claims falling within the scope of the service agent service clause to be included within the claim form. I think you can see the issue.
Yes, I have to accept the commercial force of what your lordship says. I think I'm constrained to say that it would be a matter for the rules committee rather than an issue of interpretation, because it would be odd. I'm sorry, Lord. It would be odd, I say, if the construction given to 6.11b were wider than the construction that's been given to the gateway for claims in respect of the contract, even though the word solely is not contained in that gateway.
Well, the difference is, though, that in 611(1)(a), that which contracting parties have chosen to agree defines the limits of what can be done. And I think in matters of service and jurisdiction, party autonomy is a value to which English law records very, very great significance. And you're effectively arguing that 611(1)(b) limits party autonomy when agreeing the scope of an agent's authority to accept service within the jurisdiction.
My lord, I think all I can say is that those are laudable objectives which perhaps should be taken up by the rules committee.
Thank you.
But presumably your point is this is to do with the jurisdiction of the court, not to do with party autonomy.
Yes, and that's
the language is
prescribed by the
clear.
rules. My lady, yes. Can't put it better than that. My lords, my lady, the final issue then
There's
on the
no
gate.
authority.
My lord, there's no authority on this rule as far as I can tell. There is authority in relation to the contract gateway in paragraph 6, subparagraph 6 of the practice direction, a case called Global 5000, which is in my Skellen argument, which finds that when there's a two-contract case and the claim is brought under one of the contracts, the claim is in respect of that contract, not in respect of the collateral contract. And I rely on that, by way of analogy, for the construction of this rule. That's set out in my Skellen argument. I won't go to it given the time.
I mean, you have to read 611, assuming there is no authority as to how it's to be read. A and B together, don't you? I mean, you have to read them as two connected conditions. And the first part asks whether there's a contract containing a term providing that in the event of a claim being started in relation to the contract, the words are in relation to, the claim form may be served by a method specified in the contract. So that is this case, as you've agreed with my lord.
Yes.
And then, so we have a sort of form of words, claim being started in relation to the contract. And then we have a claim solely in respect of that contract. So why are the words different? In relation to and in respect of? And what are we to take from it? For the reasons my Lord gives, why should we not say they're talking about the same thing?
Well, it would have been very easy in paragraph B simply to say, and such a claim is brought.
Because A is dealing with what the parties have agreed, so that's the big net. This is what the parties have agreed, so if that's what the parties have agreed, and a claim, so in respect of that contract is started. So both conditions have to be met.
My lady, yes.
And the alternative argument is to say that B is to prevent you from including claims falling within and without the agent's authority in the same claim form, and then trying to use 611 to effect service. So it's making it clear that any claim you seek to serve by this method must be one that only deals with matters falling within A. That would be an alternative interpretation.
Well, my Lord, that may be a different rule that could be formulated, but I say that it's not this one.
Thank you.
My Lord, I ought to move on to the final point, I'm conscious of the time, which is, for the purposes of Gateway 3, is there a real issue between Sucden and TMT? Now, there are two, the principles, of course, on the necessary or proper party gateway will be well known to your lordships. The key point, I say, is that the gateway is justified by the efficient resolution of disputes, the adjudicatory interest, which justifies bringing the additional defendant in, depends on there being an issue, which will be resolved as between the anchor defendant and the claimant and the additional defendant at the same hearing. That I take from AB Bank, which is in my skeleton argument, but also from your lordship's decision in Commercial Bankruptcy Buy in 2024, which is in my skeleton argument, but again, I'm afraid not one of those that made the cull for the bundle. Now, there's four principles which I say give effect to that fundamental point, which I'll state briefly, given the time. First, that if the anchor defendant will not actually be pursued, that it can't provide the common issue. That principle we find in Barstone and Nasima Enterprises at Authorities Bundle 10/277. Second, that equally, when all that's likely to happen is an unopposed assessment of quantum, that's not a real issue to be tried in any meaningful sense. That was the conclusion of Mr. Justice Andrews in Gunn and Diaz, Authorities Bundle 21, page 640 at paragraph 95 and 98. Third, it's necessary not only to ask, is there a real issue, but is it one which is reasonable for the court to try? That's in Erste Group Bank, Authorities Bundle 19/526, paragraphs 77 and 78, in particular 78 sub Roman numeral 4. And it's not reasonable to try a claim which adds nothing by way of quantum. Fourth, these questions about whether there is a real issue and whether it's reasonable for the court to try have to be approached in isolation. That is, before one brings in any additional defendants. That's also in Erste Group Bank at paragraph 38, Authorities Bundle, tab 19, page 513. So how does that map on to this case? Well, there are two categories of claim, which we've seen already. I start with the margin call debt. That's the $6 million claim. I say this doesn't supply the common issue for 2 reasons. First, there was not, at the time permission was granted, a real issue in relation to this claim which would ever be heard at the same hearing as a claim against Mr. Gupta. Mr. Justice Picken recorded in giving summary judgment that TMT had acknowledged the amounts that claimed were due and indeed had made part payment.
They served the defence, didn't they?
They did.
Supported by a statement of truth, saying they weren't liable.
Yes, my lord.
Now, obviously, that failed on summary judgment sometime, I think, after Mr. Justice Bright had given permission to serve out.
It did.
But I mean, let's take a situation where 2 years after permission to serve out is granted, summary judgment succeeds before the Court of Appeal. Take a different view from the judge at first instance. Is it really the case that at that point, and with limitation now expired, you can go back and say, well, look, we now know there was never any real issue to be tried against the anchor defendant, so no jurisdiction?
I think there's 2 questions in relation to this. First, is the filing of the defence and the mounting of this defence that turns out to be hopeless, but is pursued with some vigour, is that does that reveal anything about the time when permission was granted, or is it a change in circumstances? And I say that it's a very big change in circumstances from when permission was granted at the time when TMT was advancing no defence and had acknowledged the claim. But second, and perhaps more fundamentally, even if there was a common issue which could be resolved at a summary judgment stage, as between Sucden and TMT, so even if it's sufficient to say, well, there was a real issue, even if it was a bit hopeless, that there was going to be a summary judgment hearing anyway, it's never been suggested, of course, and couldn't be suggested, that the fraud claims against Mr. Gupta were ever going to be determined in that way. And so there was no realistic world in which the debt claims against TMT were going to be resolved at the same hearing as the fraud claims.
Do you think of the judge sitting in the commercial court getting his paper application in for permission to serve out necessary or proper party being, I suspect, the most commonly used service out gateway, has to say, will in due course there be an application for summary judgment against the anchor defendant? And if so, will it succeed? And if the answer to those 2 questions is yes, the necessary or proper party gateway is not met.
Well, my lord, I think I say it's simpler than that, because the judge sitting in chambers will see in the full and frank disclosure section of the skeleton argument an acknowledgement that the defendant has acknowledged the debt and has been making part payments, and there's no basis known on which he could oppose it. And the judge at that point is entitled to form the view that there's not going to be a trial of this claim. Now, one adds to that in this case that Sucden's own case is that it had to enforce this debt quickly because TMT's position was deteriorating. And so Sucden was always going to apply for summary judgment on this $6 million debt, and that was always going to come on and be resolved separately from any fraud claim against Mr. Gupta. There was never going to be a common hearing on this issue. That's the first point. Second, if one does take into account subsequent events after the grant of permission, then I say that Sucden runs into a chronological.
Just on the first point there,
Yes.
if the judge refuses permission to serve out then against the non-anchor, and the anchor defendant proceedings goes ahead, and either there is no summary judgment application or it fails, the judge is going to look pretty stupid, isn't he? If he's already decided in advance that there is no prospect of this anchor defendant being able to defend the claim, refuse permission to serve out against another party on that basis, and then all of that is falsified.
Well, my lord, there can always, of course, be a change in circumstance which falsifies the decision that the judge has made, and that, of course, doesn't make the judge look stupid in any way. It just shows that the judge was making the decision on the basis of the facts as they stood at the time. And the same question applies when one's revisiting that question at the jurisdiction challenge stage. My lord, the second issue is that if one does take all of these subsequent events into account, then I say Sucden runs into a chronological problem. Because insofar as Sucden needs to rely on the service out of the jurisdiction in Switzerland, that doesn't happen until 2026.
Well, I mean, there is a chronological issue on that way of Sucden putting their case. I agree.
So the short point is that there's no point at which there is both an anchor defendant and a real issue.
And just so what you're saying is by the time service is effected in Switzerland, judgment has already been entered into, at least on the debt part of the claim against the anchor defendant, albeit I think the expenses aspect is still out there, isn't it?
My lord has the point, yes. And then, so finally, the expenses, that's the $100,000 claim. Again, I say this doesn't provide the common issue for three reasons. First, I say this expenses claim will never, in reality, be pursued if Mr. Gupta is not brought in. And those last words are important because Mr. Charlton gives evidence that Sucden does intend to pursue this claim to trial. But it's important to look at why he says that. It's in his supplemental witness statement, his witness statement is in supplemental bundle tab 31, page 223. Paragraph 11, and in particular its subparagraphs. He says 11.1, the amount's not insubstantial. 11.2, TMT hasn't paid the summary judgment. And paragraph 3 explains what the legitimate reasons are that Sucden intends to continue to pursue its claim against all defendants. And the reason is that disclosure is likely to be required from TMT. And then over the page 224, indeed it appears Mr. Gupta intends to deny Sucden's claims, including on the basis that misrepresentations were not made, did not cause loss, and because TMT was not in a position to pay. This will require TMT to be a party in order to provide evidence as to its financial position. Now, I don't doubt that Mr. Charlton is telling the truth. That is obviously why Sucden does wish to pursue the claim against TMT, but it proceeds on the wrong basis because one has to analyse, as we know from Lady Justice Gloucester and Erskine Bank, this question in isolation. One has to look at, is there a real issue which it's reasonable for court to try if Mr. Gupta is not brought in? And the answer that emerges from Mr. Charlton's evidence is that there is not. That I say is, that's really the central point in relation to the cargo expenses. I would also say that the same chronological issue arises in relation to this, because by the time TMT is an anchor defendant, it's also in liquidation and has pleaded its defence to this cargo expenses claim, which, as set out in my skeleton argument, is no more than requiring Sucden to prove the quantum. Because there's a debt claim for this amount arising out of the MOD, as well as the fraud claim. There's no reason to think that Sucden would pursue a fraud claim when it could obtain the same amount in debt. And it's the paradigm case of claim that's not reasonable for the court to try, as in Erste Group Bank, because it adds nothing to the debt claim. So, my lord, that brings me to the end of the necessary and proper party gateway. But I say that, standing back, when one asks, is it necessary or proper to drag Mr. Gupta in for the efficient resolution of any dispute as against TMT? And can the anomalous jurisdiction be justified on that basis? I say the answer is no. Unless I can assist with anything further, those are Mr. Gupta's submissions.
Anything else? No. Anything else? No, thank you very much, Mr. Trotter. Mr. Robinson.
Thank you, my lord. I'm not going to waste any time with opening remarks. We have 4 substantive gateways to consider. The structure in which I'm going to address them are first the tort gateway in 9A, damage and jurisdiction. Secondly, gateway 9C, the claim is governed by English law, and the reason for that is that there is some overlap between those 2 gateways.
Yeah, keep your voice up a bit, Mr. Robinson.
Forgive me.
Yeah.
The third is 9B, event in England. And then I'll deal with anchor. And anchor is by far the longest of the 4 categories by virtue of the sheer number of points I need to deal with. But by the time that we get there, I will be able to make some efficiencies because we've gone through the other gateways and I've taken your lordships and your ladyship through the pleadings.
Very logical, Mr. Robinson.
Tort 9A, we say damage was sustained or will be sustained by Sucden in England, for all the reasons I'll come on to in a moment. Mr. Gupta's former counsel, Ms. O'Brien O'Reilly, said China, and Mr. Trotter says Switzerland, although I've heard my learned friend in oral submissions today confirm that he is not abandoning China. Now, I am hopeful the test is actually common ground because the test in Eurasia Sports was relied on by Mr. Gupta's previous counsel on several occasions. First, in her original skeleton before Mr. Justice Knowles. Just for your reference, it's 245 supplemental bundle, paragraph 65. She also relied on it in her permission to appeal skeleton at core page 28, paragraph 59, and again in her appeal skeleton for today's hearing at paragraph 25, core bundle 41 to 42. But my learned friend seems to think there is something between us on the test, and so let me just deal with that now. I don't need to go through the facts. that was the betting case, if you remember.
Yeah. And
the key passage, which I had thought was common ground between us, is at paragraph 21 of the authority, paragraph 21 of the judgment. It's authorities bundle 714. Page 714, paragraph 21, third line. It's where the event giving rise to the damage directly produces its harmful effects. My learned friend emphasised certain passages of this judgment to you, but not others, so perhaps we just cover that off. I think you were taken to paragraph 23 the judgment of Mr. Justice Christopher Clark in Dolphin, and I think you've read paragraph 60 as set out on this page, beginning I do not ignore. And then 24, paragraph 24, I would add that damage may be sustained in the place where a claimant is induced to provide services for no payment. That can't be taken too far, however. The mere fact that some decision or act is taken in a jurisdiction as a result of the tortious act does not necessarily find jurisdiction there. Don't think we're at odds at all so far. And then paragraph 30 on page 716. perhaps I could leave your lordship and your ladyship to read that, but essentially what Lord Justice Floyd says is that damage is sustained where the defendant in Eurasia bet and lost, because that was a case about a credit facility, i.e. an overdraft. And at paragraph 31, slightly more relevant for our purposes, it said that where there's a negligent misstatement, where the damage is said to have resulted from a negligent misstatement, it may often be the case that damage is where the misstatement is received, because, and this is the logic of the point, that is where the recipient will act on it to his detriment. Paragraph 32, there's only two more paragraphs I want to direct your lordships and ladyship to. Paragraph 32, what this says, again in synopsis, is that whether the test will be satisfied all depends on how the harmful effects are framed. Quote, I'm quoting from the beginning of the paragraph, if the damage is characterised as the impact of the failure of the defendants to meet their monetary obligations by providing security, then it seems to me that it is clear that that damage is felt in the place where the money was to be received, which was Malta. Although it is right that a conclusion that damage is felt where the claimant holds its bank account needs to be carefully scrutinised, it remains a possible conclusion. In this case, on the basis that that is how the damage should be characterised, I think it is the right conclusion. And just pause there, you may remember that in this case, $10 million of security was meant to be put up and sent by cheque to a bank in Malta, and it wasn't. See paragraph 6 and paragraph 28 of the judgment, and that is why you see the reference to Malta. It's where the security was meant to be provided and where it wasn't, by reference to tortious inducement. And then finally, 33, paragraph 33, this deals with conspiracy, which again may be helpful. Quote, the judge clearly considered that this was too simplistic a view of the harm which the claimant suffered, and that the activities and decision-making being carried on the claimant's behalf in London justified a conclusion that harm was felt here. I would have been sympathetic to that conclusion if it was established the necessary standard that the claimant was providing gambling services or facilities in London. Then it could be said that the harm caused by the conspiracy, was felt by the claimant where it was induced to provide those services without payment. And that has obvious analogies to our case. And of course, the only other point to emphasise, and again, I don't think we're at odds here, is that all that my client needs to demonstrate is that some significant part of the damage was sustained in England. And I'm not going to go through the authorities. I've been citing them ever since my skeleton in front of Mr. Justice Knowles. But just to give your lordships and ladyships the reference, it's the Brownlee case, which begins at page 660 of the authorities bundle. And you may want to look in particular at paragraphs 36 at page 679, paragraphs 40 at 680, and particularly 62D, the delta, which is at page 686, which confirms that significant damage for these purposes means a significant part of the damage. And this is all confirmed in the White Book, in the commentary at page 355. So I want to list now the reasons why we say the gateway is satisfied, and then I'll come on to deal with the arguments from Ms. O'Brien O'Reilly on paper and Mr. Trotter, both on paper and orally today. And I'll deal with deceit first, in terms of listing why we say we're within this gateway, and then I'll move on to conspiracy. Conspiracy has received very little attention so far. So deceit. It's common ground that there was a meeting in Portman Square in London, in Marylebone, between Mr. Gupta and my client. Just for your reference, that's particulars 33 at core 105, and then TMT's defence signed by Mr. Gupta, paragraph 54, supplemental bundle, page 142. And it may also be instructive to look at Mr. Gupta's own evidence before Mr. Justice Pickin, when we applied for summary judgment against TMT, to see what he says about that meeting. Supplemental bundle, page 172. So paragraph 41 begins on page 171, and I'm directing your lordship's and ladyship's attention to page 172, where on the second line at the beginning of page 172, you'll see a sentence which begins, I also attended an in-person meeting with Mr. Bailey on 22nd of June 2022 at 5 p.m. GMT at Home House, Portman Square. During that meeting, Mr. Bailey emphasised with, I think that should read empathised, our position, and told me that they know that we have sold the cargo on water at a lower price and have incurred losses, notwithstanding he, that's Mr. Bailey from Sucden, my client, continued to demand immediate payment of margin calls. The 22nd of June meeting is relevant, as we know, to what is characterised as the second representation in the pleading. The matters that are listed in paragraph 35.1 of the particulars, core bundle 106, are what we then define in paragraph 36 as the second representation. And the second representation is the product of what we plead in paragraphs 32 to 34. Which of course at paragraph 33 includes the 22nd of June meeting, where Mr. Gupta agreed that the bill of lading defined in the particulars, I believe at paragraph 21, forgive me, defined at paragraph 27 on page 103 of the core bundle as the bill of lading said to be for 9 shipping containers containing nickel. So at the June meeting, we say Mr. Gupta agreed that that bill of lading would be formally pledged by way of security, and that pledge would be more memorialised in writing, which of course it was then in the MOD. And for the avoidance of any doubt, if there were any, we plead that the second representation, and indeed all of the representations, were made either expressly or impliedly, and I will just give your lordships and ladyship the references. See paragraph 47 of the particulars, especially 47.2 and 47.3, and then see the reply 24.2 and paragraph 31. So expressly or impliedly, during the meeting on the 22nd of June, Mr. Gupta, we say, represented one or more of the matters in 35.1 to 35.3, which we say induced us to enter into the MOD and or delay enforcement. See paragraph 36. Now, we say that is enough for the purposes of this gateway, but we can get into things in a bit more detail. We say that some significant part of the damage was sustained or is likely to be sustained in England because, first, it is the June meeting in Marylebone where we were induced to materially adjust our existing position. As Mr. Gupta himself says in the evidence that I've already referred to, my client was continuing to demand immediate payment of the margin call at the June meeting. The reason for that is that no formal extension of time had been agreed in terms of the deadline to pay the debt. And the only security, I'm going to put that word in inverted commas, prior to the MOD at least, the only security my client had was possession of bills, which at most gave us a possessory right over the cargo, but not ownership rights. And if we look at the reliance letter, that supplemental bundle, page 36, this explains what the bill at this point in time in March, so this is before the June meeting, this explains the limited extent of the security represented by the bills, because you will see in the substantive second paragraph, TMT has proposed to provide SFL, that's Sucden, with certain original bills of lading as collateral towards deficit funding. The reference to collateral is then repeated in the anti-penultimate line of that paragraph in the middle. And then in the final substantive paragraph beginning TMT has made, it says TMT has made it clear to Sucden that material under original bills of lading, OBLs, are towards the contractual performance of TMT to its customers and provided only as interim collateral. SFL, which means Sucden, confirms that it will be holding these OBLs as collateral on behalf of TMT and shall not take possession of the material under OBLs without giving TMT 7 working days notice. Now, the bills were made to order, but they were not endorsed to us. My learned friend in his submissions, I think at times, conflates mere possession of bills as collateral with an ability to actually do something with it. My learned friend said orally that we could have gone off and enforced against this bill. We couldn't, not before the MOD. And that is why the June meeting is important. What changed in consequence of the June meeting is that it was agreed that the parties would formalise the security by way of a pledge so that my client, in the event of default, i.e. non-payment by 31st of December, could deal with the cargo that was the subject of the bill as we saw fit without further reference to TMT if we so wanted. But that was not the exclusive remedy.
You say that's a big change.
Big change.
2 o'clock.
Thank you.